Let's face it, if you're a grandparent stepping up to raise your grandchildren, it's a lot. Navigating family law can feel really overwhelming.
It absolutely can. You're probably asking yourself some pretty tough questions.
Yeah, like, do I actually have any rights here in North Carolina? What are my options? What should I not do?
Exactly. Those are the
Yeah.
big ones. And that's why we wanted to dig into this. We listened to a great conversation recently.
Oh, yeah.
Yeah, the folks over at Being a Grandparent Support Badgers, you might know them. They had North Carolina family law attorney Sheneshia Fitz on their Bags of Goodies segment.
Ah, Bags, they do fantastic work. We at the Fulfill Within Foundation really admire their support for grandparents. So Attorney Fitz talked about this.
She did. Right on point about these issues for North Carolina grandparents.
Okay, great. So think of this as us pulling out the key takeaways from that chat. We're going to try and bring some clarity to what feels like a really complex area.
Absolutely. Our mission here is just to break down that crucial info.
So where do we even begin? Legally speaking, what's the foundation when we talk about grandparents' rights versus parents' rights?
Well, the starting point, the absolute foundation in North Carolina law, is that parents have a constitutionally protected right to raise their own kids.
Okay, constitutionally protected. That sounds pretty solid.
It is. It's a fundamental legal principle, and it takes priority over, well, pretty much everything else.
So parents first. But I'm guessing from what Attorney Fitz said, that's not the end of the story. There are situations where that changes.
Precisely. That right isn't absolute. The key exceptions arise when a parent's actions are found by a court to be unfit or inconsistent with their role and responsibilities as a parent.
Unfit or inconsistent, okay.
When that happens, that's when the door can open for others, like grandparents, to potentially get involved legally.
Right, so if a grandparent sees that, if they're worried a parent isn't fit, what's the first step? How do they even get heard by the court?
That's where this legal idea of standing comes in. You need standing.
Standing, like the right to be there.
Exactly. Think of it as your ticket into the courtroom for this specific issue. For a grandparent in North Carolina to get standing, they generally have to show the court evidence that the parent acted unfitly or inconsistently with their parental rights.
So you can't just walk in and say, I want visitation.
Generally, no.
Mm-hmm.
You need to present a significant reason why the court should look past the parent's fundamental rights and consider your involvement.
Okay. And how does that actually happen? What actions can a grandparent take?
There are basically two main ways to go about it in court.
Okay.
First, the grandparent can actually start the lawsuit themselves. They file a custody action, becoming the plaintiff.
Filing their own case. Got it. What's the second way?
The second way is if there's already a custody case going on, maybe between the two parents.
Right, like a divorce or separation.
Exactly. In that situation, the grandparent can file a motion asking the court to let them intervene, essentially, to join the existing case as an interested party.
So either start the fight or join one that's already happening if it relates to the grandchild's custody.
That's a good way to put it.
Okay. Now, something Attorney Fitz apparently touched on, which I know is huge for grandparents, is this fear. This fear of getting DSS, the Department of Social Services, involved, or just the courts in general.
Oh, absolutely. That fear is very real, very understandable. People worry about, blowing things up or making things worse.
Right. What did she say about that? Specifically about, say, the fear of parental rights being terminated.
She really emphasized that terminating parental rights is a huge deal legally. It's not something courts do lightly or quickly. It's sort of the last resort.
Okay, that's reassuring. So what does happen if DSS steps in and takes custody?
Well, first, DSS gets legal custody. That means they make the big decisions. But, and this is important, the child might actually be placed physically with a relative, like the grandparent. That's called kinship placement.
Kinship placement. So the child could still be living with the grandparent even if DSS has legal custody.
Yes, that happens quite often. But DSS still holds the legal reins, and during that time, the parents usually have work to do.
Work? Like what?
DSS creates a case plan. It outlines specific goals the parents need to meet to show they can safely parent again. Things like parenting classes, therapy, stable housing, addressing substance abuse issues.
Okay. And there are checks, court dates.
Yes, regular court hearings are held to monitor the parents' progress on that plan. DSS reports to the judge. The parents have a chance to show what they've done.
It sounds like it could drag on, though. What if parents struggle? Maybe they can't find housing, like you mentioned.
That's a real issue Attorney Fitz brought up. Limited resources can definitely slow things down. Finding affordable housing, accessing therapy, these can be major hurdles.
So the courts understand that. They don't just terminate rights if someone misses a deadline.
Generally, yes. She stressed that courts usually want families to reunify if it's safe. They'll often give parents time and opportunities to make progress, even with setbacks. Termination really comes into play when a parent consistently, over time, fails to engage with the plan, doesn't show effort, doesn't make progress. It's about the pattern.
Okay, a pattern of non-compliance, not just struggling. That's a really crucial distinction. So if DSS is involved, what should grandparents be doing? Just waiting.
Oh, definitely not just waiting. Attorney Fitz really highlighted how vital it is for grandparents to be present, to be involved.
How?
Well, becoming that relative placement, the kinship caregiver, is huge. It provides stability for the child, but is more than just housing them.
Right.
As the person caring for the child day to day, the grandparent is in the perfect spot to tell the court what's really going on, how the child is doing, if they need therapy for trauma, what their needs are.
So they can provide updates to the court?
Yes, absolutely. They have a voice in the process because they're directly involved in the child's life.
Yeah.
Their input is valuable.
That's empowering. Okay, another term that comes up a lot in these cases, guardian ad litem. What's their role?
The guardian ad litem, or GAL, is appointed specifically to represent the child's best interest in court.
The child's interest, not the parents, not DSS's.
Exactly. Their sole focus is the child. They're kind of an independent voice for the kid. In DSS cases, a GAL is typically appointed.
And what do they actually do?
They investigate. They'll visit the child at home, maybe at school. They talk to the child, the caregivers, teachers, therapists. They participate in meetings, review documents, and then they write reports for the judge with their findings and recommendations.
Recommendations about what's best for the child?
Yes. Custody, visitation, services the child might need. Their perspective is purely child-focused.
And does the judge listen?
Very much so. Attorney Fitz emphasized that GL recommendations carry a lot of weight. She mentioned cases where the judge followed the GL's advice, even when it differed from what DSS or the parents wanted.
Wow. Why is that?
Because the GL has often done that deep dive. They've seen the child, talked to people, gathered information specifically about the child's well-being. They offer that unbiased, child-centered view.
Okay, that's really good to know there's someone specifically advocating just for the child. Now let's shift a bit. Attorney Fitz talked about intact versus non-intact families. What does that mean in this context?
Yeah, that's a really important legal distinction for grandparents. Intact family doesn't necessarily mean mom, dad, and 2.5 kids living together perfectly.
Right, not the traditional picture necessarily.
Legally, it means there's no active court case about custody going on between the parents. They might be separated, they might never have been married, but if there's no lawsuit filed about custody.
The court sees it as intact for these purposes.
Pretty much, yeah. And in those intact family situations, Attorney Fitz was clear. Grandparents generally cannot just file for custody or visitation on their own.
Why not?
It goes back to that fundamental parental right. Unless there are serious allegations about the parent being unfit, which would give the grandparent third-party standing, the court presumes the parents are acting in the child's best interest, and grandparents don't usually have grounds to interfere legally.
Okay, so if the parents aren't in court fighting each other over custody, grandparents generally can't initiate a case just for visitation.
That's the general rule, yes.
But what about when the family isn't intact? Parents are divorcing or there's already a custody dispute filed.
Now that's different. If there is an existing custody action between the parents, then grandparents can potentially get involved.
How? By intervening.
Exactly. They can file that motion to intervene we talked about, specifically asking the court to consider granting them visitation rights.
But is it automatic? If they intervene, do they get visitation?
Not automatically. They usually still need to show a couple of things. First, that they have a pre-existing substantial relationship with the grandchild.
Okay, they can't just show up out of the blue.
Right. And second, crucially, they need to convince the judge that continuing that relationship is actually in the child's best interest.
Always back to the child's best interest. Makes sense. What if, say, mom wants grandma involved, but dad objects because he and grandma don't get along?
Attorney Fitz addressed that too. Usually one parent simply objecting because of their own issues with the grandparent isn't enough to block visitation if the court thinks the relationship benefits the child.
So the parent needs a better reason,
Yes, the objecting parent would generally need to show the court specific reasons why contact with that grandparent would actually harm the child's well-being. Not just that they personally don't like them or have issues with the other parent. The focus stays on the child.
Got it. Okay, what about the kids themselves? Do older children get a say in any of this?
They can, yes. In North Carolina, judges have the discretion to talk with children who are 12 years old or older to hear their preferences about custody.
12 and up. How does that usually happen? Is it formal in the courtroom?
Often it's done more informally in the judge's chambers, their office. Just the judge and the child, maybe the GAL and DSS cases, or sometimes an attorney might request it in a private case. It's meant to be less intimidating for the child.
And does the judge have to do what the child wants?
No, not obligated. The judge listens and considers the child's preference. But it's only one factor among many.
Why only one factor?
Well, judges understand kids can be influenced,
Yeah.
by one parent or the other. Or they might not grasp the full picture or the long-term consequences. Attorney Fitz mentioned, sometimes kids, even after difficult experiences, still say they want to be with a parent because of that natural bond. So the judge weighs it, but it's not the deciding vote.
Right. Balancing the child's wishes with their overall safety and well-being. Okay, let's talk practicalities. Informal versus formal custody. Lots of grandparents end up caring for grandkids through informal agreements, right?
Very common. A parent might drop the child off. Maybe they sign a piece of paper, get it notarized, saying grandma can take care of things.
Yeah, like a makeshift guardianship document. Do those hold up?
That's the risky part. Attorney Fitz really cautioned against relying only on those. While some schools or doctors might accept them. Yeah, might. They aren't legally binding court orders. There's no guarantee they'll be honored everywhere for every decision. A grandparent could hit a wall trying to enroll the child in school or consent to medical treatment.
So that notarized letter isn't ironclad legal authority.
Definitely not. It leaves the grandparent in a legally vulnerable position. The parent could theoretically change their mind and take the child back at any moment without any court process.
Okay, so what's the advice for grandparents in that informal situation, even if things seem fine now?
Her strong recommendation was to seriously consider filing a formal complaint for child custody to get a proper court order.
Even if the parent agrees?
Yes, even if it feels amicable. That court order is the only thing that provides clear, undeniable legal authority to make those crucial educational and medical decisions and secures the arrangement.
Can they use the fact they've been caring for the child?
Absolutely. The existing informal arrangement, the length of time the child has been stably living with a grandparent, that's all strong evidence they can present to the court in support of getting that formal order.
That makes a lot of sense. What if everyone is actually on the same page? Parent knows they need help, grandparent is willing, everyone agrees the grandparent should have custody. Is there an easier way than a full-blown fight?
Yes, definitely. Attorney Fitz mentioned what are sometimes called friendly complaints, or more formally, consent orders.
Friendly complaints.
Yeah, basically everyone agrees to file a custody action together, or agrees on the outcome once it's filed. There's no real dispute, but they use the court process to get that official, legally binding order.
So they consent to the judgment.
Exactly. It
Oh.
formalizes the agreement, gives the grandparent the legal paperwork they need without the conflict. It's a smart, proactive approach in those situations.
That sounds like a really practical option. Now, she also gave some specific advice for grandparents in really tough spots, right? Like if one parent has passed away and maybe the other parent wasn't involved but now wants the kids.
Yes, those incredibly difficult scenarios. Her message was powerful and direct, especially for grandparents who've been raising the children in that situation.
What was it?
Don't be afraid to file for custody. If the surviving parent suddenly appears after being uninvolved, and you genuinely believe it's not in the children's best interest to be uprooted or placed with that parent, you need to act to protect them.
Even though that parent has rights.
Even then, you can argue that the parent's prior lack of involvement or other issues make them unfit, or that their actions are inconsistent with their parental rights, and that staying with the grandparent is in the child's best interest. She shared an anecdote about a client who did just that, successfully got custody when the uninvolved father tried to take the kids after the mother died.
Wow. That takes courage, but it sounds essential in those cases.
It really is. It's about protecting the stability and well-being the grandparent has provided.
Okay, so wrapping this all up, pulling together Attorney Fitz's key advice for grandparents, whether things are formal or informal, what are the main takeaways?
Several key things. First, and she repeated this, Don't fear the court system. That formal court order is your strongest protection and gives you the clearest authority.
The order. Okay.
Second, seek legal advice. Talk to an attorney. Even if cost is a worry, many offer initial consultations for free or low cost. Legal aid is also an option. Don't guess about your rights.
Good advice. What else?
Know that resources are available. She mentioned you can often find the basic custody complaint forms on the North Carolina Courts website, nccourts.gov. That can help demystify the starting point.
So nccourts.gov. Good resource.
And finally, really, knowledge is power. Understanding the process, the terms, the options. It reduces fear and empowers grandparents to make good decisions for their grandkids.
That's incredibly valuable. So the big picture here is, yes, parents have fundamental rights in North Carolina, absolutely. But the law does recognize situations where grandparents need to step in and provides ways for them to do that.
Exactly. Whether it's working within the DSS system or filing a private custody or visitation action, there are pathways. Understanding things like standing, the court process, the GAL role, and crucially, the difference between a handshake agreement and a court order that's key.
It really is. And thanks again to organizations like Being a Grandparent Support Bags for bringing experts like Attorney Fitz in to share this kind of vital information. You can check them out at bagsickgoodlife.org.
They do great work, and knowledge sharing like that is so important.
Absolutely. So maybe here's a final thought for our listeners who are grandparents raising grandchildren. Even if your current informal setup feels okay right now, is it truly secure? Would formalizing your role, getting that court order, give you, and more importantly, your grandchildren, greater peace of mind and the solid legal ground to advocate for everything they need?
It's definitely something worth considering carefully. Explore the resources, maybe have that initial chat with an attorney. It's about ensuring you can always do what's best for those kids.
Well said. Check out bagsisgoodlife.org, and of course, for more about us, visit fulfillwithinfoundation.org.